In the last few years, the Colombian Constitutional Court has been at the forefront of landmark decisions implicating various dimensions of social cohesion. Cases on abortion, social security, and same-sex marriage, for example, have brought to light the complex moral, legal, and political questions that judges face in upholding constitutional guarantees. With its rich cultural diversity, embedded patriarchal structures, and a history of conflict and transformation, Colombia finds itself at the crossroads of building the rule of law, mitigating social divisions, and managing majority sentiment. So we set out to understand what dilemmas judges face in adjudicating social cohesion issues in the country. What kinds of principled and pragmatic considerations do they take into account? What tools and strategies do they use to tackle the issues at stake? And how do they respond to divided opinions within and outside of the court? To shed light on the intricate landscape of Colombian jurisprudence, joining us in this episode of CALS Chai Chats is Justice Alejandro Linares from the Colombian Constitutional Court. Justice Linares, welcome, and thank you for being with us here today.
Many thanks for the invitation to you, Diane, and also to Mario for inviting me to this interesting subject.
Before we get into a discussion of the topic, I thought we'll just ask you a little bit about your career, which has spanned different sectors and areas. You started as a lawyer in private practice and international business. You have an interest in finance. You've served on the public service, and you've lectured in universities. How has this varied and versatile experience informed your work as a judge? Has it had any impact?
Definitely, it has had an impact in the sense of giving you a lot of experience and judgment as to have a global view of how to solve problems in our society. The Colombian society, the same as many Asian societies, is unequal. There are structural inequalities, and this experience that I have both in the private and the public sector helped me construct solutions that could be implemented by a court. In theory, the theory of the separation of powers have told us that the judicial branch should not intervene in the design of public policy. However, given the dysfunctional political organs in Colombia, it is important for courts to intervene so as to help the transformation of a country to fight inequality and poverty. So all this experience has helped me to contribute to judicial decisions that try to solve the most important issues of society.
We'll talk about separation of powers. We'll come back to that topic in a moment, Justice Linares, but I want to pick out on what you mentioned about the Colombian society, and I think this is very important for the benefit of our listeners here on this podcast. So you've clearly had a range of experiences, as we've noted, as an academic, policymaker, advisor, and now constitutional court judge. So from your observation and experience, what are the most pressing social issues in Colombia, say, over the past 2 decades or so?
I think we have, as a country, we have too many problems. One of our main issues is the increasing presence of narcotics traffic, cocaine particularly, and that has created a lot of course, corruption and violence, but it also has distracted the the main objectives of our political branches. In other words, we have issues of inequality and issues of poverty that the state also has to fight. But the national budget has been primarily allocated, that there is a lot of uh, budget funds allocated to security, to arms, to the military, to fight corruption and to fight also the narcotic dealers. But very recently, the budget for education, for health, for housing has been increasing after the peace process. So part um, of our country signed in 2016, President Santos entered into a peace agreement in order to solve this violence and these narcotics problems, and try to focus on how to improve the living conditions of people, particularly in most uh, in areas of the country in which there is no presence of the state.
So there seems to be a plethora of issues at stake here, but ultimately they go to economic and social inequalities by the looks of it. So have some of these issues arisen in concrete cases or disputes before the court in Colombia, especially during your tenure? And could you highlight a couple of notable examples?
Yeah, most of the examples are reflected in what we call structural injunctions. Um, Not necessarily in my tenure, but we follow the president of the court in those areas in which there is judicial enforcement of socio-economic rights. This is the people from Europe and the United States look at us as a very activist, but I do believe that given the context of Colombia, it is normal for courts to intervene to protect certain types of rights. Our 1991 Constitution has a lot of rights in favor of people, political, civil, economic, cultural rights, environmental rights, and most of those rights require not only a right, but also a remedy. So what courts do is to issue remedies in order to transform society in the good sense. I mean, I do believe that the political branches, basically the executive and Congress, have a mandate to allocate funds progressively to help solve the problems of our country. But sometimes courts have to intervene when there are certain dysfunctionalities in the political organs. And what is interesting in Colombia is that after 1991, after the Constitution created certain remedies, such as the tutela action is some sort of a constitutional injunction that allows you to grant, it allows courts to grant specific remedies to enforce rights. After the 1999 Constitution, most of the social problems of the country have been judicialized in the sense that people believe more in this tutela action, in this constitutional remedy, rather than going to a senator or to a representative of the House of Representatives to try to solve their day-to-day problems. So what is interesting in Colombia, after the 1991 Constitution created certain remedies, is that people more and more go to the courts to enforce rights. So that has given um, a result which is not perfect, is not ideal, but it is a result in which the court, our court particularly, intervenes, for example, in how to implement the peace agreement or how to protect um, indigenous people when there are infrastructure projects applying ILO Convention 169, or we have structural remedies for the health system that we continue to monitor. Um, we have decided that prisons have created a situation of massive violations of human rights, which account to what we call unconstitutional state of affairs. And also, we declare the unconstitutional state of affairs in the case of the killings of former FARC guerrilla members that signed the peace agreement. So there has been killings of people that were former FARC guerrilla, and that the court that issue got to the court, and the court indicated that the government was not complying with the security measures agreed upon in the peace agreement. And also, we had a decision on displaced population because of violence. We said at that time that it was important to undertake structural remedies to protect the displaced population within Colombia. This is people that have been displaced because of violence of their lands, particularly peasants in the rural areas. So there's a lot of situations and tensions that our court has solved, not because we love to be activists, but basically, and that's my personal view, because the political branches, namely the executive and the legislative branches, have not acted on time to solve these pressing issues of society.
So this is a fascinating spectrum of issues that you raise, Justice Linares, around social rights and social justice. I guess many of these involve balancing complex policy considerations and choices that sometimes might go beyond legal interpretation. And you mentioned one of the concepts you use, a sort of unconstitutional state of affairs. I wonder whether you can elaborate a little more on the sorts of mechanisms and strategies that the court has used to balance these competing interests in some of these diverse areas that you referred to.
Yes, these types of court intervention are based upon our constitution, which has open texture. So there are certain general concepts, for example, the right to education, or the right to housing, or the right to a clean environment. Of course, it is not only to interpret and apply the constitutional law, but also to read the Constitution from the point of view of the pressing needs of society. So those of those complex problems that got to our court, we have to face a dilemma. One is to abstain. So we could say, we will not act upon this issue because that's an issue that corresponds to the Congress or corresponds to the executive to solve. That's one idea. There are some cases in which the court has applied self-restraint, but there are other cases in which the court has decided to intervene. So it is a very difficult balance between intervention and self-restraint that the court has to balance and try to be in a way moderate without being too interventionist. We try not to intervene, but the problem is whether or not judges should adjudicate on those type of issues which are complex. The problem is that most of the issues that come to our constitutional court is what Fuller characterized as polycentric issues. In other words, any decision that we take not only has effects between plaintiffs and defendants, but it has external effects, positive or negatives, of on other parts of the population. For example, if you adjudicate a housing right to one person that is in the middle class, it creates a problem with respect to people of lower classes that did not have access to justice. And therefore, the question is, that intervention to the court has economic effects on other people that are also looking for housing rights. So it is so difficult, particularly given the scarcity of resources, so that courts, most of the time, after the intervention, what they do is to allocate resources of society without going to Congress. There has been a lot of criticism of those decisions of the court, but the problem is that Congress has not acted upon to solve such issues such as health, education, social rights. So those are very complex issues. So I think at the end of the day, the important thing is to have a right balance. And of course, it is a vision that goes beyond interpreting and applying the law. And an additional complexity of this is that every judge, we are 9 justices at the Constitutional Court. Each of us has a different lecture, a different reading of the text of the Constitution. So you could have a text saying, text of the Constitution says you have the right to dignified housing. The question is how you read the words of the Constitution, given your background and given your experience. And that creates an interesting debate when we are going to take this type of complex decisions. And that's why we have used several times what we call structural injunctions, or a more recent term that we have used is we have moved from an adversarial adjudication to a dialogic adjudication, in the sense that most of our structural decisions put into dialogue the different parts of society, communities, governments, NGOs, and other actors in the region, so that the solutions are not taken by the court, but rather the court is a facilitator of certain types of solutions that require not only assignment of public resources, but also acting by certain corporations. So it is a very interesting move when we create, for example, committees to review how to improve certain types of rights within certain communities. For example, we have used that approach in extractive industries, or when there is a economic activity in ethnic community lands, or when we want to enforce the prior consultation of indigenous communities in certain areas of the country.
Well, that's extremely interesting, Justice Linares. I was wondering whether I can push you a little bit more on the idea of dialogic justice, and ask you how you feel the different stakeholders respond to this model of judicial decision making. Is there a willingness to participate in such a model of decision making? And do you think this model of decision making produces better outcomes uh, that can handle the division in public opinion and in society around some of these complex polycentric issues?
Well, that's a very interesting question, given that there are so many stakeholders. But we try to protect the most vulnerable people of our country in our decisions, not always with success, but that's at least that's the intention. But for example, in the extractive industries, for example, we have cases of exploitation of oil and gas or coal in certain areas of the country, in which there are communities and indigenous communities, and what we say is do a prior consultation before implementing, let's say, an economic project, and try to negotiate the best solution for everybody. Of course, that is very easy to say and very difficult to implement, but at least the court has understood that problems are not solved with a judicial order, because there is much more in society than a judicial order to do certain things. And I think there is a trend in Colombia and in the world, I would say, um, to the corporate social responsibility of enterprises. And there are some indications that there are some human rights concern of corporations. So that's a new trend that you see, and corporations are more aching to accept that type of dialogue, even though it delays the economic returns of projects, but it also helps communities to understand those type of important projects in certain areas of the country. Uh, we have had issues with the executive. The executive does not like uh, such type of dialogue, of transparent dialogue, because you have some sort of a monitoring on how to comply with their constitutional obligations. They don't like to be monitored, not even by civil society nor by the courts. But that's life in Colombia. The executive do not like what the constitutional court orders. But the problem at the end of the day is that we are not complying with the mandates of our constitution. And as I said before, our constitutional has plenty of rights. And what people look at the courts is to have remedies instead of rights in paper. But it's not easy. We have claims that we are not very democratic, because five people, remember that we are nine justices, the majority of our decisions require five votes. And recently, when we took the decision on abortion, the president said to us, the president, who is a Catholic president, said that five justices could not take decisions for the majority of the country. So the democratic legitimacy is one of the claims that are being made against the court, even by the president of the republic.
That's really interesting that you brought up the question of democratic legitimacy, Justice Linares. But from what you have explained so far, it seems that the court has secured a great degree of public trust in Colombia. And I think this is important because matters on social cohesion or justice invite really strong public opinions on various sides of the divide across a spectrum of ideas. So, to what extent does public opinion matter in addressing some of these complex issues that you have mentioned, Justice Linares?
Oh, I think public opinion is so important, and we have so much pressure from public opinion, from the media, from the social networks, and we receive a lot of criticism, but also we receive some support, particularly from people in rural areas or minorities. There are plenty of activity all around social issues, social rights, decisions that do not have an effect on one people, but that have given the equality mandate of our constitution, have let's say, an external effect on other people. There are a lot of criticism, and particularly the most traditional lawyers in the country also criticize the court because it is very difficult to draw a line between law and non-law. In other words, the process of interpreting the law in has in the process, there are some personal views, there are some experience views, there are some inequality positions that give you to interpret the law in a certain way, not with the traditional methods that we are taught at law school, like read the text of the law and only the text of the law, or give or read the different provisions in a law in a coherent way. We are criticized also by the certain part of the academia, and also we are criticized by the more liberal academia that want us to be more progressive. So it is interesting. For example, if you look at the academia says that we abstain from deciding too many issues, but the government and the mayors and the governors, I mean, the executive branch of government at all levels, criticize us as being very interventionist, activist, whereas the academia, the critics of the academia are all the way around. In certain issues that are very divisive, we receive a lot of pressure from the public opinion: abortion, same-sex marriage, um, adoption by same-sex couples, euthanasia. There are very difficult moral issues in our society, in our Catholic society, that have a lot of pressure from public opinion and from the majority of the people, being a majority of a Catholic population. So there are certain decisions that are counter-majoritarian, even go against the views of the majority of the country, or the Catholic Church, indeed, which is very powerful in our country. But we are judges, and we have to protect also minorities, which is a mandate of our constitution.
I'm glad you brought up those issues. And this is a good segue for us to turn to specific cases. So in 2016, the court approved same-sex marriage, and I can imagine this to be quite controversial given the reasons that you just mentioned earlier. Of course, this is also at the same time an important social justice and rights issue with ramifications on social cohesion. Could you explain the thinking behind this decision, Justice Linares?
Well, the thinking of this decision is really interesting, and behind the decision of our court, which I voted in favor, is basically the principle of equality, or the principle of non-discrimination, and the free development of personality. What is interesting in this case is our constitution in section 42 says that a family is formed between a man and a woman, and also the constitution says and other types of families that could be formed. So our constitution defines family as marriage of men and women, but also has some language which is not very clear, but which allows persons to create a family not between marriage of man and woman. So what the court says is any person has the right to create its own conception or vision of family, and family is not what the Catholic Church has indicated for centuries, or of a contract between a man and a woman. And our civil code in section 113 defines marriage, the contract of marriage, as between a man and a woman. The civil code does not allow two women to marry or two men to marry, and has a binary definition. What we did was to say that given the new conception of family, given the free development of personality, and given the deficit of protection that gay couples had, the court had to intervene and interpret that people of the same sex could contract, could celebrate the contract of marriage. That decision was really important, particularly for people who live together, are same sex, have been discriminated against for years or for centuries, and wanted to get married. I mean, there is no obligation to get married. Simply, we gave the right to people to marry, even if they are not of different sex. So in the end, it's a decision aimed at protecting certain minorities that have been discriminated and that have not been adequately protected by the legal system. So that's basically the core of the decision. This is the decision in 2016. It's a follow-up of a decision that was taken in 2011, when the court said that it was possible for people of the same sex to enter into a marital contract, which was not marriage. So
Right.
what people really wanted is to have access to the contract of marriage regulated in the civil code, not to have access to any type of what the court called in 2011 a marital contract. A marital contract has no legal tradition in Colombia. So what we did in 2016 was relatively easy, in the sense that what we did was to implement a 2011 timid decision that allow a marital contract. And what we did in 2016 was to say yes, you could enter into a marital contract, but also that marital contract would be what we call in our civil code the contract of marriage, with all the effects, the patrimonial effects and the obligational effects of the contract of marriage as defined in section 113 of the civil code.
I'm wondering whether we could return to the recent abortion decision again, and ask you to explain a little more how the court responded to these divisions in society, and what was the sort of legal reasoning you used in your judgment.
Similar to the case of same-sex marriage, the issue of abortion shows an evolutionary approach in our court. Back in 2006, the court had indicated that there were 3 cases in which the voluntary interruption of pregnancy was not a criminal activity. Those 3 cases were violation of the woman, the affection of the health of the mother, and the suitability of the fetus. In other words, whether the unborn would be suitable for a healthy life. Those 3, let's say, indications were an exception to the the criminalization of abortion. That was back in 2006. Now, a new abortion case came to the court, and the court decided to go further progressively, and indicated that besides those 3 indications of grounds for a non-criminal abortion, that in order to protect rural women and a woman of lower resources, the court had to intervene to protect the most vulnerable woman that could not pay an abortion, or could not have access to abortion, or even though, or also that were afraid of going to an abortion because they fear prosecution from the criminal authorities. So what the court said was, we are going to open up another window for non-criminalization of abortion, and the court indicated in a recent decision that is being signed in these days, has not been published yet. The decision was to decriminalize abortion before 24 weeks of pregnancy. And the ideas behind this decision includes the ideas behind Roe versus Wade, free development of personality, protection of most vulnerable communities, progressive protection of the fetus. There are a lot of arguments that go into, let's say, progressive protection of life, but also in a balance, in a proportionality balance, with the rights of women to decide whether to not to have a baby. So what the court did was a balancing between the progressive rights of the unborn with the rights of women to have an abortion. So it's interesting decision. It also obeys to an evolution in the jurisprudence of the court, in the presence of the court. That decision was not taken out of the blue, but also was based upon a 2006 decision, and what the court did was to progress uh, in a further decriminalization of the voluntary interruption of pregnancy. Of course, when you are in the middle, you receive criticism from everybody. So the Catholic Church was very, very hard at the court. The president of the republic was very, very hard at the court. But on the side of the feminists, they criticized the court as well because we went not further to have a total decriminalization of abortion. Of course, I would want to decriminalize abortion. That would be my position. But we have to balance the different views and the different opinion with respect to such a difficult question, which is the voluntary interruption of pregnancy. Again, our constitution has a provision that says life is protected. The question is, how do you read that constitutional mandate in a case as difficult as abortion? It is not an easy interpretation, but if you have a textual interpretation, you could also say that that the decision is unconstitutional. But at the end of the day, what a constitutional judge has to do is to take into account the different views of society, not only the majoritarian view, but also a view that it is balanced in a complex society.
That's a very interesting account, both in terms of the history and the incremental way in which you developed the jurisprudence, but also in terms of how you responded to the different views in society. So we're coming to the conclusion of what has been a very interesting conversation. But before we conclude, I just want to ask you a question about the engagement you have with other constitutional courts in other parts of the world. What impact has your jurisprudence from the Colombian Constitutional Court had on constitutional courts in other parts of the world? Have they borrowed some of your concepts and used it? And reversely, has the Colombian Constitutional Court also borrowed concepts from other Supreme Courts and other constitutional courts in other parts of the world? And do you think this sort of cross-fertilization of jurisprudence has helped sort of jurisprudence across the world to grow and evolve?
I think that's a very interesting question, Mario. Definitely, ideas travel. We have formally and informally. From a formal point of view, we have an open constitution to the human rights conventions, and particularly, we have applied what we call the constitutional block, which is certain parts of human rights treaties that are incorporated by reference in our constitution. So we apply, for example, the Inter-American Convention on Human Rights in particular cases. That is what I would call a formal dialogue. But what is most important is the informal dialogue. And we, of course, borrow from the European Court of Human Rights. We borrow from the Inter-American Court of Human Rights, but also we follow the Indian decisions or the South American South African, decisions, and we borrow from also from some Turkish decisions. We try not to be very abusive in the borrowings, and we try basically to borrow principles and not particular decision. So we have a vertical dialogue with the Inter-American Court of Human Rights, but what is more important is the horizontal dialogue, particularly with other courts of the world. For example, we have a visit to the Federal Constitutional Court of Germany. That's the part of the borrowings that we do. So I would say that the informal conversations have an impact on our thinking, on the way we approach the text of our constitution. And also we have influence in the region, particularly in Central America and certain countries of South America. But as I said at the beginning of the question, ideas travel, and we try to borrow the good ideas and apply them in an appropriate manner. But we also export ideas to our neighbors, and we have some influence in the region.
Now, that's really interesting, Justice Linares, because at the beginning of this conversation, before we started this podcast, we had a little informal chat about the basic structure doctrine and how the Colombian court has also imported ideas from the Supreme Court of India, which is in a common law jurisdiction. So I find this cross-fertilization of ideas, borrowing, importation, exportation to go sort of beyond the legal traditions that we find ourselves in, Justice Linares.
Definitely. I find, for example, that the basic structure doctrine from 1973 it is not a borrowing, it's some sort of an idea that helps you solve a problem. Same in abortion, it is not that we take Roe versus Wade and we put it we cite Roe versus Wade in our decision. But the right to privacy, the free development of personality, are ideas, are judicial philosophies that permeate our decision. To me, what is important is that good ideas that protect people from the abuse of power travel all around the world. And there is some sort of a common ground. The language that is used goes beyond the frontiers of the different legal traditions.
This has really been an illuminating conversation, Justice Linares, in terms of the history, strategies, and conversations that judges use and take into account in dealing with social justice. So thank you very much once again for providing us with a rich insider's perspective on the thought processes, principles, and norms underpinning the court's approach to social cohesion issues.
Thank you very much for the invitation. Thank you, Mario. Thank you, Diane. And I sent to Mario the reference of a book that I edited with Oxford University Press, articulating some of the views that I have exposed here in this podcast.
I'll make sure our library gets the book.
Okay, thank you very much.